about perception. To what extent does that take some level of consideration in the Supreme Court dealing, so that people's experiences with the Supreme Court, or any, not just the Supreme Court, but the judiciary, is what is captured in surveys conducted by the likes of IEA, capturing people's experiences with the different arms of government, and in this case, the judiciary. So would you disregard the experiences of the people that captured in these surveys as against what your experiences are about?
You see, now I'm a former judge. I could be lecturing, I could be training, I could be actually doing surveys and so on and so forth. But when we come to what a judge sitting on that bench over that case is expected to do, they are so expected to apply the law to the facts as they have understood the facts. And you see, that's why they would, even at the Supreme Court and at the Court of Appeals, they also do, because when it's a multi-judge panel, you always do meet to discuss, because sometimes you've got this angle but you didn't quite catch that angle, and you get a more holistic picture, because the group dynamics works positively when you do that. And but to arrive at your conclusion, you can't say, fellows, in the last case when we did this and that and we all agreed, the people were upset, so this one, let's let it go this way. Or, okay, two of you disagree and the rest agree. No, that cannot be. That is not how it's supposed to be. Now, that is why, you see, of the people who are interviewed or surveyed, I would like to know how many of them bothered to read the judgment. It's not therefore I will grant or therefore I refuse. That is the conclusion. How was it arrived at? It's the reasoning, the judicial reasoning in arriving at the decision. That is also crucial. Yes, it can run into 30 pages. I've seen, well, not in Ghana, but in other panels, courts I've sat on, somebody's opinion, one opinion, being over 100 pages. Yeah. Did you read it before you would say you agree or you don't agree? You have to read it. You must.
What constitutes the quality of justice? And this is something I know you've been very passionate about. I followed your presentations at The Hague. You still hammer on quality justice. What's the details of that?
Quality justice, in a nutshell, would be characterized by, well, as I mentioned, credibility and effectiveness. But credibility in itself would be fed by how knowledgeable the judge is. You know, that one you would call it competence, how competent the judge is. That's very important. Competent, firstly, there's a basic competence, know your law. Yes, it doesn't, these days we all agree, doesn't all reside in the bosom of the judge. That's why certainly throughout the Commonwealth, continuing judicial education is harped on all the time, and they go back to the classroom and be taught about trends and what is happening in other jurisdictions, and new enactments, complicated enactments. You take them through provision by provision and so on and so forth. So it's competence. It is also independence. Independence is as I said, it's sine qua non. You cannot have justice. The word justice itself is not even just a common word. It's even I would say it's a religious word. It's a biblical word. Yes, it is just. It is as it should be. Yes. So that's why independence and integrity. You cannot be independent and lack integrity. And if you lack integrity, you cannot be independent. So that they go together. And then efficiency. You know, sometimes the delays in the whole thing from the commencement and through on and on and on and on and on and on, that can give an impression that they're up to no good, or I won, but by that time the money was worth nothing to me, therefore I did not get justice. A litigant can say that. Yes. So efficiency is important. Efficiency is also partly personal to the judge, and to a very large extent also your workspace. How efficient are your